All right. Let's now consider Karen Campbell versus Household Life.
May it please the Court, my name is Michael Farron. I'm appearing on behalf of Karen Campbell this afternoon, seeking a reversal of the trial court for granting a summary judgment based upon a finding that this insurance application was unambiguous. We argue that that finding is factually and legally incorrect. And I'd like to
do you want to retain any time for rebuttal?
Yep, that's the next thing I was going to say. Thank you, Your Honor. 5 minutes. Okay. And what I want to do actually is the facts in this case are very straightforward. My clients refinanced their home in 2006.
We're very familiar with the facts.
Okay. And our position is very simple, that this insurance carrier decided to deny the claim only after they had knowledge that Mr. Campbell passed away, 15 days afterwards.
15 days, was it?
15. That's admitted in a request for admission. It's in the record. They say that their statement is, we knew he died. We didn't deny the claim, or we didn't reject the policy application until after he died, but that had nothing to do with it. Okay. We don't believe that. Okay.
Does it make any difference? In other words,
yes, it
had they accepted the coverage yet?
Well, our position is they didn't have a choice to accept the coverage for two reasons. One is the application itself did not give them that opportunity except to reject it for one reason, and that is if the person was over 71 years old. That's what it says. Okay. So factually they had no right to reject the coverage, and legally they had no right to reject the coverage, and that's the Harriet case, which I want to talk a lot about here in a second.
Wait, before we get on to that, doesn't the disclosure say in subparagraph 2, there will be no insurance until the insurer has approved your application, if one's required?
That's correct. It does say that, and that's part of the ambiguity, because elsewhere it says the insurance is effective the date you buy it, plus the only condition the insurer gets to look at to decide whether to reject it or accept it is whether the person is over 71 years old or not. That is because nowhere else in the application does it say if you answer yes to the fact that you had diabetes, if you answer yes to the fact that you had any other medical condition, there's 3 questions, that therefore you're not qualified. It doesn't say that.
Doesn't the statute also contemplate an acceptance by the insurance company? I mean, 627.681?
Actually, the statute, and the statute I came about because they argued in their reply brief that the 71-year-old thing is by statute and that they're not allowed to put other conditions on it. In looking at the statutes, I believe the statute 627.553 says that unless they show that less than 75% of the people who are eligible for this credit life insurance take that credit life insurance, they must insure all without reference to any health problems.
Well, I mean, this section of the statute says all credit life shall be evidenced by a policy, certificate, or statement of insurance, and then it says upon acceptance of the insurance by the insurer. And within 60 days of the date upon which the indebtedness has occurred, the insurer shall cause the policy to be issued.
But that doesn't say they have unilateral they can reject it for any reason they want, and their application doesn't give any reasons that they could reject it. It doesn't, Your Honor. It says
acceptance suggests to me that that they have a free will there. They can accept the risk or not.
Well, no, not in credit life insurance. And that's why I want to talk about the Harriet case, okay? Because the only thing that the statute and the application give them the right to decide whether to accept it or reject it on is the 71-year-old question. If you look at the Harriet case, in fact, if this court were to decide to follow the Harriet case, which was reversed because there was fraud involved, and that's the key difference. There's no fraud involved here. It is a roadmap to why this case should be reversed. Because in that case, the courts, the second district, went into great depth, and I've quoted it in my brief, as to the policy behind credit life insurance. The fact that you do not look at the health characteristics. It says, on the other hand, permitting insurance companies to avoid claims on the ground of concealment of any health factor affecting the individual risk ignores the fact that credit life is written on the basis of the aggregate, not the individual risk. For sound reasons of public policy, it must be. Okay? That is the reason behind credit life insurance. They had no basis in the application to reject it, and they had no basis under the law to reject it. Yet the court found that the application was unambiguous and that they had a unilateral right to reject it. And oh, by the way, it was after we knew he was already dead, and we were going to have to pay the benefits after only one premium. And then we were not allowed to go into discovery, which they later, in response to Mrs. Campbell's inquiry, when she asked them, well, why did you deny it? They said, well, because he had diabetes and heart disease and he was overweight. We said, and that's contrary to our underwriting guidelines. But yet those were off limits in discovery, even though they had made them relevant. They had made those underwriting guidelines the reason they were trying to justify their after-the-fact decision to reject the policy, yet we weren't allowed to get them. And we assert that was also error.
Why does that matter? I mean, isn't it the question of whether or not they get to accept or reject? Isn't that really the question, not why they accept or reject?
Well, I think if you go past the fact that they have the right and give them the right to reject, then, and if they're asserting that is the reason, they are the ones that are making it an issue. Okay? Their letter saying it was our underwriting standards and our guidelines that you just didn't meet, that puts a scale on what it puts the rules, it makes them the rules. They're making those the rules. Okay? So they made those the rules. Now, but yet it's in a little black box where we can't see it.
If the issue is, do you have a right to accept or reject?
Right, it's two tiers.
Then their reason for why they accept or reject is
right.
Not.
Well, there's two. I think there's two tiers. One is
you're pretty much going to hang your hat on your first argument, not your second. The second argument only comes into play if the first argument.
That's correct. That's correct. That's correct. But I don't think we even need to get to the second argument because I think it's clear. I would strongly urge the court to look at the Harriet case because the difference, the only reason.
What case is that you keep referring to?
Okay, it's National Life Insurance versus Harriet. It's in my reply brief.
I was looking at your initial brief.
No,
it didn't make your initial brief?
It didn't make my initial brief, and the reason was because I got onto this case when they argued there was only one reason they could object to the 71-year-old provision was part of a statute, but they still had other bases to reject. That's when I found this case. And what this case is it's factually, it's the same as our case with one huge difference. What the couple in that case did involved the purchase of a car, the survivor, and I can't remember whether it was a husband or wife, knew that the other spouse was going to die very shortly and went ahead and financed the car and bought credit life insurance and did not disclose to the insurer that they knew the death was imminent and certain. And therefore they would get a free car because when the other spouse died, the credit life would pay it off. Well, the court went into great detail about credit life and why health issues really aren't part of credit life. And in fact, they cite the what's called Bulletin number 421 from the Florida Insurance Commissioner, basically saying that that's not allowed. Now, I tried to find Bulletin 421, and I couldn't. This is a 1972 case, so I don't know.
But Harriet was a case where the court held that there was even in the absence of a query by the insurer, there was an affirmative duty by the insured to disclose that the fact of that the person had cancer.
Correct, because that in essence turned on fraud. In other words, that couple tried to commit fraud on the insurer.
Oh, that didn't turn on any kind of fraud that we knew about prior to that time, common law fraud. It wasn't an affirmative misrepresentation. It was a case where the court held that there was an actual duty to come forward with this information, which suggests to me that it's because it's material to the decision of whether or not to issue a credit life policy.
No, actually that's not what that case said.
It's not material. How could the court have
I'll answer that question, okay? What the court said was normally we wouldn't go into the health in credit life. It just falls in all the actuarial numbers and it comes out in the wash because there's so much, it's so profitable and there's so many people to buy it. And the court went on through that. But what they said was the reason they reversed it was that it has long been the policy that when someone knows of a factor, that misrepresentations, omissions, concealment of facts, and incorrect statements shall not prevent a recovery under the policy of insurance unless it's fraudulent or material either to the acceptance of the risk or the hazards by the insurer. So in that case, there was an imminent death. In other words, they knew she was going to die or he was going to die, okay? And yet they went ahead with that. This is not the facts in our case.
But that clearly suggests that if they had disclosed it, the insurance carrier would have had a right to say, no, we're not issuing the policy.
Well, because it was imminent, but there's no imminent death in our case. In fact, he did die.
Imminent doesn't have anything to do with whether they have a right to accept it or reject it.
Well, no. The reason they had a right to reject it was because the court believed
they had a right to reject it.
No, the court believed that the insurance was purchased for a improper purpose, and that was knowing that that person was going to die shortly just to get the car paid for.
So your argument is that the death here, the timing of the death, really is immaterial, that once they made application for the credit life policy, as long as they were under 71, the insurer had no right to refrain from issuing the policy, even if it was the next hour or the next minute or the next day.
That's correct, absent some kind of fraud or misrepresentation, which there isn't here. There's no allegation that my client answered anything.
So their request for the insured to fill out a health questionnaire and sign a medical release is just an exercise in futility.
Well, it is because the application and the statute doesn't give them the right to deny it based on that. In other words, that could be a universal application, which could apply if less than 75%.
Zero me in on that part of the statute that doesn't give them the right to
okay, this is 627-533, cited in my
627-533 with no
553. I'm sorry, Your Honor.
553.
Right.
With no subparts. That's what you're talking about.
No, it's subpart 2. Okay.
Okay, zero me in means take me right to
okay, I'm going to take you right to it. It says, in the last sentence, it says, the policy may be issued only if the group of eligible debtors is then receiving new entrants at the rate of at least 100 persons yearly, or may reasonably be expected to receive at least 100 new entrants during the first policy year, and only if the policy reserves the insurer the right to require evidence of individual insurability if less than 75% of the new entrants become insured. And earlier in that paragraph, it says that the only time that they get the right to make a medical condition, and this is in credit life insurance now, a condition is if there's less than 75% of the then eligible debtors elect to pay the required charges.
So they got to do it the same for virtually everybody, or they don't get the singles?
Correct. Well, unless it's under 75%. So that application is so ambiguous because sure those questions are there, but they don't tell the applicant, you're not going to get the insurance if you answer yes to this. They don't say that at all.
How do you square that with the language, there will be no insurance until the insurer has approved your application?
Well, I square because again...
That's part of, that was the application.
That the only reason they can approve or reject it by the statute is if he's over 71 years old. So they can't make up a reason to reject it now that we know he's dead. And that's what we allege happened here.
And how do you square with 627-681, which says, upon acceptance of the insurance by the insurer?
Okay, maybe I'm not being clear, Judge. Let me try it this way.
Yeah, because I'm not getting
it. It is, the insurer does have a right to accept it or reject it, but not for any reason they want to invent. Only for the reason in the statute.
If they're over 71.
That's correct.
Well, then the application policy should be very short.
It should, but and we didn't make up the application policy, and that's why it's ambiguous, and that's why it violates the statute I was just discussing, 627-553. So the point is the court granted a summary judgment based upon a finding of unambiguity in the application. We allege that, number one, that is wrong, because the application also contradicts the provision you keep citing and says that the
I
insurance
only
will be...
cited it twice.
I'm sorry?
I only cited it twice.
All right, twice, Judge, I'm sorry. It contradicts that when it says that the insurance will be effective on the date of the application. They're the authors of that. They can put in whatever questions they want. That doesn't make them relevant and applicable with the law. We can't control that. My clients are regular people. They fill out the application. They paid their premium. Mr. Campbell dies. They hadn't rejected the policy. And by the way, that's one more point I'll make, and then it's not like they found out things in that 15 days that made them reject the application. They rejected the application based upon what was on the application and nothing more, and the knowledge that he was already dead.
Yeah, well, that would be pretty significant knowledge.
Yes, it would. And that's
But you say they could have rejected it. They could not have rejected it even the hour after they made application.
As soon as he
right?
signed it.
Unless it was because they were overage.
Unless it was because of their age, or unless there was less than 75% of participants and they had it in their policy that they could do that, as the statute says, which isn't in this record anywhere.
Okay, thank you. All right, we'll hear from from Household Life.
Thank you, Your Honor. May it please the Court, Jason Joffe on behalf of Squire Sanders and Dempsey.
So what about this 71-year-old then?
Your Honor, if you look at 627.6785, that disclosure basically mimics the requirements of Florida
Give me the
statute.
statute again, 627 what?
627.6785, subparagraph 3. And I believe both Harriet and the 627 it's said in its brief as 533, but I guess it's 553 because I couldn't find a 533. Those have to do with rate promulgations. And if you go back to 627.6785, it says, no credit life rate or credit disability rate shall be deemed to comply with allowable rate criteria contained in this part if it contains age restrictions which make ineligible for credit life those debtors or lessors 70 years of age or under. And then it goes through credit disability, which is also referenced on disclosure and has that age too. It also says, however, the credit life, the coverage shall be provided at a minimum until the earlier of the maturity date of the loan or the loan anniversary at age 71. That disclosure is mimicking Florida statutes. And to be quite honest with you, Your Honor, I think it's a little difficult to argue an ambiguity in a disclosure or an application when you're simply trying to comply with Florida statutes. You're actually trying to comply with the law. And I don't believe that those statutes deal with whether you have to accept or not. It has to do with complying with rate promulgation, which I don't think is really relevant here, but has to do with the Office of Insurance and the type of rates you can charge for different risk assessments. So I would say that complying with Florida statute can't create an ambiguity in a disclosure. I would also point out that the alleged ambiguities also don't appear on the face of the application. They appear on the face of the disclosure. So there is no ambiguity alleged by the appellant in the application. I do want to address real quickly the Harriet case, which opposing counsel...
It was in the reply brief.
Yeah, it was in the reply brief. Harriet says a lot of stuff about credit life insurance. But one of the more important pieces of the case is where it says, the commissioner did, and this is talking about this 421, which nobody can find. The commissioner did state that this bulletin, 421, would, quote, in no way interfere with the company's right to underwrite the insurance according to normal procedures. So that bullet 421 that Harriet relies on, which I believe is very distinguishable from this case, in fact, all the cases appellants cite are distinguishable.
How is Harriet distinguishable?
Pardon me?
How is Harriet distinguishable?
A policy was issued in Harriet. Every case cited in the appellant's brief, a policy was issued. It was a coverage dispute. So Harriet, along with every other case cited, a policy was issued. That wasn't the case here. That's the primary reason. Also, what Harriet says is exactly what Your Honors were saying, that inherent in Harriet is the assumption that under general contract principles, which is what governs insurance and under the laws of Florida, An insurance application is an offer that has to be accepted in order to create a binding policy. I'm aware of no law, and there's no case cited that says when you make an offer to somebody, the other side is forced to accept it. I mean, that's essentially what appellant is asking for here, is to force Household Life to accept this application. Especially on this arguing that there was an ambiguity, when, Your Honor, the cases cited by appellant that talk about ambiguities in insurance contracts, insurance policies when they're issued, which didn't happen here, talks about viewing those policies under an objectively reasonable standard. And with all due respect to opposing counsel's argument, when you have documents that say applicant, application, and et cetera over 10 times, when there's language that says it's subject to approval so they can determine eligibility. If the insurer denies your application, you will receive a full refund of the premium. No insurance until the insurer has approved your application. And this is all subject to approval of your insurance application if one is required, and one was required here. That is not objectionably ambiguous.
The appellant contends that it says insurance is effective on the date of the application.
Correct. Yeah, I'm sorry, Your Honor.
Does it?
If it was accepted, and that process, I know it sounds a little inherently contradictory, but this court, I believe it's this court, in INSURANCE, recognize that that's acceptable. And this is a quote from the case INSURANCE. A policy takes effect on a specified date, even though the contract may be subject to acceptance of an applicant. So you can make an application. There can be a period to review and to decide whether you want to accept it, and then the coverage can start previously. That's been held to be acceptable.
Tell me what this sentence means in 627.553(2) that begins with the second sentence, a policy on which part or all of the premium, et cetera, all the way down to 75% of the then eligible debtors. What does that sentence mean? Can
you repeat that? I couldn't find that section because it's not cited that way in the brief, so I apologize.
Oh, it isn't cited?
I think it was just a Scrivener's error. I think he cited 533, and I couldn't really tell what
627.553(2), a policy on which part or all of the premium is to be derived from the collection from the insured debtors of identifiable charges not required of uninsured debtors, shall not include in the class or classes of debtors eligible for insurance debtors under obligations outstanding at its date of issue without evidence of individual insurability unless at least 75% of the then eligible debtors elect to pay the required charges.
I'll be perfectly honest, that's a little too much for me to process right there, but it does say at the end there, without evidence of individual insurability.
I'm going to have to study it myself.
Yeah, but I think the idea is that statute still, from what I hear, still contemplates you can require underwriting, you can require an application. That's the way I read it, and I'd have to look at it a little bit further, Your Honor. I apologize not being able to address the question.
How does the insurance company accept the application?
The statute provides for it. I don't have it's cited in the briefs, cited in our brief, but they issue a policy. They issue a written policy.
Do they write a letter and say, we're accepting this, or do they just issue the policy with the deck page? Or?
I believe they issue a policy. I believe they issue a policy as contemplated by statute, and the statute also contemplates a difference between an application and a policy.
Was your client paid for the insurance?
Pardon me?
Was your client paid for the insurance?
They received a premium, an initial premium, which is common practice, and then it was returned to them when they declined it.
And they also, I guess, scheduled future payments? Is that the way that works?
I mean, that's how it works because it's contemplated. I don't think there's any hesitation here that they would like to issue the policies. It says right there they make money off the policies. So it's fine. I don't know if this was actually financed, but it is a schedule of payments. And that brings up another interesting point, Your Honor, is you can't have insurance by estoppel. That's cited in our brief. And it's conditional receipt. There's a minority of states that say if you accept a premium, you get a little window before you decide I'll candidly admit that, but Florida is in the majority of states that say conditional receipt doesn't apply in Florida. Coverage isn't valid until there's been an acceptance. There's a Wisconsin case that's cited in our brief that kind of talks about the difference between the majority and the minority.
How long does the insurance company have to accept the risk?
That's a good question. I think it's a reasonable time. I think certainly in...
Days. Didn't I see 60 days in there somewhere?
I think the statute, the policy has to be issued within 60 days of decision. It might have to be...
decision. Okay.
I believe, I'm not positive. I believe it's a reasonable time. And, Your Honor, this would be a completely different case if this was 6 months, 4 months. This happened pretty quickly. 15 days. And also, there's conditional receipt. There is an exception to conditional receipt that it's contained in the case law. It's no secret. And there's a case cited by opposing counsel Johnson where if you accept the premium, if it's an overly long period of time, then it's a different story. There's a waiver argument. Not the case here. There's also Johnson also talks about that was a case where, and that's the only case I saw in appellant's brief that comes even close here. And that was where a premium was accepted. The insurer found out about the disqualifying condition and continued to accept the premiums. Waiver. I mean, that's not the case here.
The unsettling aspect of this case is that we really don't know what your client's underwriting criteria is because you didn't produce it and the trial judge sustained your objection. So it might be that if this fellow hadn't died within the 15 days, that they'd have just rocked on and issued the policy, and it would have been immaterial to them from an underwriting standpoint, right?
That is a fair point, Your Honor. There is no allegation.
And these are relatively young people. They're overweight, and they got diabetes. But I mean, what was the length of the credit obligation? 5 years or something like that? What was this? A purchase of a car?
I'm not sure.
Purchase of appliance.
It was a refi. It was a refi of a home.
Oh, refi of a home. So what was the amortization period? That was the word I was looking for.
I don't believe that's in the record, Your Honor. Oh, joint life insurance from 120, so that's 10 years.
10 years. 41-year-old diabetics. I mean, they're probably going to live that long. And if it turns out that your underwriting criteria would have provided for the rejection of an application such as this, I would think that you would have produced that. Here it may just be luck that this fellow died before the insurance company accepted the application.
I understand your concern, Your Honor. I would come back to really affirmance is appropriate here based on 3 cases.
And when they rejected the application and denied the claim, they stated that the reason was the diabetes and the obesity and all that, and that might have just been complete, a complete fabrication, right?
Your Honor, I understand your concern. Before we admitted that we denied after knowledge of the death occurred because we got the documents pan that out that we got notice, but.
Right, but you suggested that the reason for denial was the information disclosed in the health application, and that might have been a lie. Right?
Well, there's no evidence of that, Your Honor.
The only evidence that is in the record is that when they tried to find that out, when the plaintiff tried to find out what your underwriting criteria was, you objected and said it was irrelevant, and the trial judge sustained the objection. Right. So.
Your Honor, I come back to Suarez, Scalise, and Sorense. I haven't found any case law that says you can force somebody to accept an offer.
But I mean, suppose this insurance company accepts applications under ordinary circumstances with this kind of information in the application, and they do that across the board. That meets their underwriting criteria. Why should they be able to reject this application just because this guy happened to die within 15 days?
It is confidential proprietary information, Your Honor, and I understand your concern, and I understand the emotional aspect of this and the death that was involved. But Suarez, Suarez is on point here. You don't have, it was a credit life application, the person died 3 days after, and there was no acceptance. He was of bad health, and the court said, he was in bad health, they didn't have to accept the app, they didn't have to
You're
accept
right, they could have rejected it because the applicant was blue-eyed.
I agree, Your Honor, it's an offer. I think...
And said we rejected it because, they could have said that it was because he was blue-eyed.
I don't know if you can go that extreme, Your Honor. I don't think there's any law that compels them to accept the offer or write the policy. It is an offer. The application is the offer. It's the proposed insured that's making the offer. With respect to the discovery, Your Honor, Suarez, the most interesting thing about Suarez, that case was decided on a motion to dismiss. So arguably facts virtually identical here don't even state a cause of action, and you wouldn't even get to discovery. And it is a bit, you have to do some mental somersaults to get to...
The point of one of the points of Harriet, though, was that credit life insurance is kind of a different insurance animal. That these creditors are out there, they're selling product, and they are also agents for a credit life provider, and they don't typically find out, do a physical examination or engage in a health thing, because of the nature of the beast, because the risk is spread among so many people that they're relatively indifferent about health. And that was the reason that in Harriet the court said, well, because of that, you got a special duty. You can't just, when you know you're terminal, you can't just run in and buy a car and get yourself a life insurance policy that way. That's just not fair.
I agree. And I think...
Doesn't that rule of fairness cut both ways, though? I mean,
I think Harriet... You did say in most instances, Your Honor, and I think Harriet recognizes that, and I think the statute you read to me also recognizes that there's just no black letter law that says you have to accept an application. I come back to that pretty powerful portion of Harriet that says the commissioner did state this bulletin would no way interfere with the company's right to underwrite the insurance according to its normal procedures. So even the bulletin that kind of warned of all the policy behind credit life insurance and how it's a different beast, it still doesn't say that you don't get to underwrite and issue policies and evaluate each prospective insured.
The appellant contends that you can accept or reject, but you can only reject based on the 71 years old. You would dispute that and say you're not limited to that. In fact, you can get the medical records, you can get the information that was requested, and you can make a denial on that basis. And in this case, they did. They made a denial on that basis.
Yes.
Okay. So assuming that's the case, why don't the appellants have an opportunity to check and see if your denial is in accordance with your policies and procedures? Other than it's proprietary.
I also don't think it's relevant.
Why not?
Because we're not required, this is going to sound cold and it's not meant to be cold, but I really don't see anything that says we have to give a reason.
But you did.
But what we did, because when a widow writes of an insurance company and says, why are you denying my policy? We wrote back and gave a reason. I respectfully don't think we were required to.
But aren't you bound by that? Once you tell them we denied it because you're a diabetic or because the medical records revealed this, aren't you bound by that?
Well, I'm not so sure we're bound by it. If somebody made an offer to me and I told them why I denied or I didn't accept their offer, if I'm lying to them, I'm not sure that creates a cause of action because I'm still not obligated to accept their offer. And I think their argument supports that because their argument is application disclosure said 71 years of age. That was the only qualifying condition. Well, if that's the only qualifying condition, why do you need the discovery? Why is it relevant? And that's my response, Your Honor. We did not. My time's almost up. We did not locate any case, and I do not believe any of the cases cited in the appellant's brief that state that an application creates a life insurance policy. In fact, Scalise kind of spells it out again. Suarez, Surency, and Scalise kind of govern here. In Scalise, it says, according to the general principles of both contract and insurance law, in the absence of an express provisions to the contrary, the application of one seeking insurance constitutes an offer and doesn't create an insurance policy. So there's to say that ambiguities create policy, it has to be expressed under, it has to be an express statement under Scalise. Real quickly, in the reply brief, opposing counsel relies on a bunch of cases that talk about ambiguities in applications in creating insurance. I believe that's a little misstatement of those cases. Those cases all involved, again, every case cited, a policy was issued, which isn't the case here. But those cases involved when an insurance company was trying to rescind coverage based on a material misrepresentation in an application. Completely different than here. And what the court said in those cases is when there's an ambiguous question in the application, you can't use that to kind of go back on your word and take away the policy. None of the ambiguities here are questions. In fact, none of the ambiguities here are in the application. Your Honor, we believe there's the trial court was correct in granting summary judgment. There's no issue of fact or law, and we would request that you affirm the judgment from below. Thank you very much.
Thank you, counsel. All right. We have 4 minutes and 12 seconds to go.
4 minutes and 12 seconds. And
Is this language very important here, this language that I read to him? Is that important to your argument?
Absolutely, Your Honor, because...
Well, it doesn't jump out at me what it means, so would you explain to me what it means?
Okay, yeah, because I'll tell you that I read that statute about 10 times.
Okay, well, I'm only at 2 right now.
I know, and I agree with you, okay? And I apologize if it was the wrong statute number. I obviously could have fixed that if, I didn't mean to not tell him what statute it is. But it is very important because it goes to his argument that this is an offer by my client to his client, okay? Right. It's not that. It's their form.
What does the language mean?
The language means that if you must write credit life insurance, if you're going to offer this to the body of the people, okay, right, who are applying for this.
And make them pay for it.
And make them pay for it.
Okay.
And there's more than 75% of them participating in this group as it defines it, the year or whatever, you must write that credit life insurance. And the only thing that you can condition it upon is the last sentence of subsection 2, which says the policy may exclude from the classes of eligible for insurance classes of debtors determined by age. Okay, it doesn't say 71, but it does say age. So that makes this different than my client's bringing it on.
If an applicant goes in and has terminal cancer, and they tell the credit life insurer, I got terminal cancer,
but I'm 65.
But I'm 65 years old. According to your interpretation of this, they've got to write the policy.
That's right, and the reason they have to is found again in the Harriet case in the sentence after the sentence he read.
They don't tell them about it, then the insurer.
Right.
Because if they do tell them about it, they got to write it anyway. So how is it ever material?
It's not in credit life, and that's the whole point. And that's why if you read the Harriet case, and I can tell that you have read it, that if you read it again, that's why I urge that this court follow it. I know you're not obligated to follow the
So the lesson here is that if you have a terminal illness, run down there and buy something and get yourself credit life.
That's right, as long as you're honest about it, yeah. Because the mistake that they made in the Harriet case was misrepresenting it. And if I could read this next quote, which is the one after where it talks about they could still have the, according to, quote, normal procedures, the court said, but there is no clarification in the meaning of that proviso. We mentioned Bill 421 to show that in general, credit life insurer must take the borrowers as they come. And the prevalence of credit life insurance in consumer finance estimated to be written at least 85% of the transaction makes the business statistically safe. So to answer your Honor's question is, yeah, they get a bad deal on that one because the guy was honest and he had cancer and he told them about it and they got to write the insurance. But because it's statistically safe, it's okay because they're going to come out making money in the end anyway. And that's exactly the point of the Harriet case. That's why credit life insurance is different. That's why the court explains that it's different. And that's why there's a statute which says they have to accept it. And that's why the trial court needs to be reversed. They can put whatever they want on this application. They could put on, well, you have to give us your high school transcripts, a disclosure. But they still would have to have a right to use that as a reason to deny it, which they don't have. And the law does not allow them to use these health insurance. And that's why the court erred in granting, saying it was unambiguous. And I urge you, if you don't do anything else, to please read that Harrell case and then think about the fact that we have no fraud here, and please reverse this.
All right, sir, thank you.
Thank you.
All right.